Hello, everyone, and welcome to our podcast, What the is Regulation, where we explore different facets of alternative dispute resolution with guests from all over the world. I'm Andra Curutiu, and today I will be joined by my co-host Mihaela Tarnovschi.
Hi, I am Mihaela, and in today's episode we will explore alternative dispute resolution in Nigeria. We are joined by our guests from ADR Society University of Nigeria. Courage, Stanley, and Victoria, welcome to our podcast.
Thank you, Courage, for joining us and replying to our invitation to join your knowledge on ADR. You are the host of Lex Insights podcast. Would you like to start by giving us some information about ADR in Nigeria and what projects are you focused on?
All right, thanks for the opportunity to speak on this particular platform. It's quite an opportunity. Yes, I'm the host of the Lex Insight podcast. The podcast is a weekly podcast that talks about the intersection of law and technology, the opportunities and the challenges it brings for the legal profession worldwide. So, about the introduction on our ADR Society, the president of our ADR Society is currently in this recording, so I would like to give him the opportunity to give us a background on ADR Society, University of Nigeria.
Okay, good afternoon. It's a pleasure to be in this meeting. The ADR Society, University of Nigeria is a student-based association formed in 2018 in the University of Nigeria, Nsukka, by young, vibrant students with the sole aim of fostering the learning of ADR practice in the student community. And we are a body which puts the needs of each student at heart. And this has been done through some seminars we have organized and some workshops. For instance, in June 2019, we organized a 3 days professional master class in conjunction with the Nigerian Institute of Arbitrators and Conciliators of Nigeria, where they trained some of our students, and the role of associates was conferred on them. So we are a student-based body, as I said, and we hope to do more in the university and also make the practice of ADR and the learning of ADR something that will last in our Nigerian society, because we need most of our young lawyers to embrace the ADR practice. Thank you.
Thank you, Stanley and Courage, for your brief introduction. If possible, we would like to ask you now maybe to briefly describe how is the legal system in Nigeria organized, and for example, is it a federal state like the United States, or is it rather a national harmonized system like it is in the Netherlands? Just to help us get a better understanding of your legal system.
Thank you for that question. The Nigeria's legal system is a composition of the received English law. Nigeria was colonized by Britain, and as such, during the colonialism, any law that was made by Britain was passed down to us, and it applied automatically in our legal system down here in Nigeria. So that's the first part of our Nigerian legal system, the received English law. Then the next one is the common law, that is the decisions. So whatever the judges do down there in Britain also applies to us, because it is part of the law. And common law is what the judges do. So whatever case that they decide on, it's like a precedent for any case, and also applies to Nigeria and other parts of Africa that were colonized by Britain. Then next is the customary law and the Sharia law. The customary law and Sharia law are the laws that were in force even before colonialism, that is pre-colonial era. The customary law applied in the different tribes ethnic communities in Nigeria. Of course, Nigeria is comprised of more than 250 ethnic communities and tribes. So each particular community or tribe or ethnic group has its own laws, has her own laws that governs them. Just like the Igbo community, the Yoruba and the Hausa, the three major tribes in Nigeria, they they all have their particular laws governing them, and so these laws have been given the force of law, and then they apply in even in courts. So there are customary courts in Nigeria that decide their cases and that rule, and then the laws that govern the country. The Sharia law also it's applies specifically in the north for the Muslims, that is the Islamic persons. Sharia law applies to them. So these are what makes up the Nigerian legal system. So the question whether it's is like a federal state like the USA or harmonized system like the Netherlands. So I'm going to say that it's harmonized like the Netherlands, but in the sense that there's a particular constitution like the Constitution of Nigeria, which is the 1999 Constitution of the Federal Republic of Nigeria as amended, applies throughout the country Nigeria. So but then in US we know that each state has its own constitution, so it's like they are independent bodies than the capital or whatever. So yeah, but in Nigeria one constitution governs the whole country. So and then each state has their own different laws and codes, just like in criminal when it comes to criminal matters. And Nigeria has two particular major laws governing criminal matters in Nigeria. The South has their own criminal rule or regulation, which is called the Criminal Code Act. So the Criminal Code Act governs the southern part of Nigeria, while the Penal Code governs the northern part of Nigeria on criminal matters. So that's just how the legal system is structured down here in Nigeria. And then finally, the Supreme Court, the hierarchy of courts in Nigeria is mostly maybe might be the same with other jurisdictions. The Supreme Court is the supreme, as the name implies, is the highest and the apex court in Nigeria, followed by the Court of Appeal, then the Federal High Court, State High Courts, National Industrial Courts, then before we get the magistrates and other customary courts. So thank you very much.
Thank you, Courage. That was very interesting to learn about your system. I hope that your law students are not having a very hard time learning all of these types of laws, because to be honest, coming from a civil law system where we only have statutory law, for me, I think it would be quite a challenge to learn both the customary law and the Sharia law and the statutory law and probably some common law as you described. And actually, when you talked about customary law and the fact that, you know, it depends on each community that there is in Nigeria, I would like to ask you if you can maybe develop more on whether or not you have any type of mediation form of alternative dispute resolution that is sort of community-based, because sometimes, you know, that exists, and I wonder if that is true for Nigeria, perhaps. Maybe you can develop on that, or one of your colleagues could answer as well.
Okay, actually, we don't really have a community-based arbitration law per se. So the Arbitration and Conciliation Act of Nigeria is made to govern the whole regions in Nigeria. However, some states go ahead to enact arbitration laws. And why this is done is because the Arbitration Act of Nigeria is old. It was enacted in the 1980s. So it doesn't work alongside the present realities. So a state like Lagos State, they have their own arbitration law, which is kind of recent, but it's not really community-based because it also depicts the provisions of the Federal Arbitration Act. Also, some mediation houses in Nigeria, like for instance, in Enugu State, we have the Enugu State Multilevel High Court. So these mediation houses also enact, or I won't really say enact, okay, they have some laws that guide mediation, or it's not really community-based, because if a person in Lagos has a matter with somebody in Enugu and they bring it to the Multilevel courthouse, it will still, the law of the Multilevel courthouse will still govern the case. So it's not really community-based. So, but the final law that has power more than all these different acts is the Arbitration and Conciliation Act of Nigeria. Thank you.
Thank you, Stanley, for your answer. Indeed, we have also read recently that for the first time in Nigeria, arbitration and other forms of alternative dispute resolution has been given a constitutional backing as being then a constitutional means of solving disputes. And I would like to ask you then, like, what do you think it means for Nigeria in itself, like for the development of ADR in Nigeria, and how in general it can impact the use of ADR in your country?
Okay, thank you very much for that question. Whether there's a constitutional backing or not, the law and the courts, like common law, recognize arbitration as an effective means of settling civil disputes. So right from time, even before it was given this constitutional backing, the courts also permit settlement of disputes outside the court. So in our terms of contract, we always include or embed the alternative dispute resolution. They put it as a clause in a contract to say we can either explore negotiation or mediation or conciliation. So like I said, there are different ways, alternative ways of dispute settlement that is indigenous to Nigeria before colonialism. Like I gave you an example, the Imoh tradition. So the constitutional backing is not what determines its practice, because it has been always here. Alternative dispute resolution has been always here. However, it did not have that position. There's this status quo or this rank that it gives it. But because of this recognition in the constitution currently, it gives ADR an elevated position and a different perspective in the settlement of disputes. So the section that provides for the backing of the alternative dispute resolution in the constitution is section 19, paragraph D of the Constitution of the Federal Republic of Nigeria 1999 as amended. So it provides for the settlement of disputes by international treaty and by arbitration, mediation, conciliation, negotiation, and then adjudication.
Thank you, Courage, very much. From my understanding, indeed, in Nigeria, then arbitration was kind of taken from a means of dispute resolution by the parties themselves to then be recognized by the Constitution. And then, as you mentioned, the Supreme Forum to enforce it would be the King and the Supreme Court. And actually, I would like to ask you, what is the attitude towards the enforcement of arbitral awards in Nigeria? Then are the awards easily enforced? And would you say that Nigeria is also arbitration friendly in those terms? What is the perception towards the New York Convention and the enforcement of the awards in general?
We can firmly say that Nigerian courts are on the winning side of accepting the enforcement and recognition of this arbitral awards. Basically, because aside the fact that a party can decide to, go back on the award that has been given to him by the arbitrators after the arbitral agreement and proceedings, the court takes its time. The same, we could say that the same effort that the court puts in giving judgment when it comes to litigation is almost the same efforts they put in enforcing arbitral matters that come to them. There have been cases of both local national arbitration matters as well as international commercial arbitral matters that have come to our Nigerian court, and they've been considered and treated as an effective one, because we know that Nigerian court of now see ADR as one of the effective methods of dispute resolution.
Thank you very much, Victoria. That was also very insightful. It is great to know indeed that the parties are satisfied with the award, and of course, ultimately, it depends on the financial disposition of the party concerned, whether or not they will comply with the enforcement and how they would comply with it. And it was also indeed very good to know, as Victoria mentioned, that the courts put a lot of effort in the enforcement of the award. And I really hope that with further developments in Nigeria, then it would actually make it a very attractive place for investors and for companies if the system works this well. And ultimately, I just wanted to ask you, what would you say is at the moment perhaps the most popular alternative dispute resolution method in Nigeria? Would that be negotiation, mediation, arbitration, conciliation maybe?
Okay. I wouldn't say we have a definite statistics as to which alternative dispute resolution is the most popular or commonly used in our country, Nigeria. But one can firmly say that arbitration takes the upper hand because it looks like one of the most favored ADR techniques in Nigeria is arbitration and conciliation. People merely make use of negotiation and other ADR mechanisms, but arbitration and conciliation is the trend because I think it's because of the features, the peculiar features that come with arbitration. You know, the whole confidentiality, the ability of parties to pick who would represent them, as well as the arbitral panel, their voluntariness, the time and the cost. And, you know, in Nigeria, most of the arbitral cases that we see when we do case review is arbitral matters between companies that really value the confidentiality of their agreement. So top companies, you know, all companies that want to, you know, get into dispute of most times because there is either a misinterpretation in the terms of their contract or a party has, you know, defouled one of the terms of the contract. But ultimately, we can say that arbitration is one of the most popular ADR mechanisms that is being used in Nigeria recently.
Yes, indeed. Thank you, Victoria, for answering this question. It is indeed really interesting to know that arbitration is highly valued in Nigeria, besides and conciliation as well. Ultimately, I would like to ask you, perhaps this would be our last question for the podcast of today. How did the arbitration courts in Nigeria deal with the whole corona situation? Do you have any input on what kind of technology has been used, or do you think there are some better things to be done so that the process of deciding the cases will not be stopped in case of a pandemic or any kind of, you know, kind of disaster that would make meeting in person not possible? So yeah, if you have any insight on what technology has been used, that would be great.
Perhaps you can also discuss the Africa Arbitration Academy Protocol on virtual hearings, which has been shortlisted by the Global Arbitration Review for this special recognition award that will pay tribute to the response by the international arbitration community to the coronavirus pandemic. What does this protocol exactly entail, and what are some of the main measures that aim at facilitating the use of technology in arbitration as described by this protocol?
All right, thank you for that question. I believe it's the last question. The impact of COVID-19 pandemic in our judicial system in Nigeria, it's most likely similar to other jurisdictions across the globe, in the sense that when the pandemic hit the country initially, we all witnessed the lockdown, and the lockdown affected even the courts. So most courts, the Minister of Justice gave an order for all courts to be closed for the time being until the pandemic is checked, and so it affected the speedy resolvement of issues. But then during the pandemic, the court, there was something like the online courts that tried all these trivial matters, all these little cases, especially for those that were caught maybe moving without the requirements or the guidelines during that is for the pandemic guidelines in the movement and everything during the lockdown, those that were not cooperating with the directives of wearing masks and working during curfew hours. So those persons were tried on these online courts. So the impact of the COVID-19 pandemic and the court system in Africa as a whole was very hard because, as we know, Africa is a developing continent, is still developing. The technology has not been fully um, utilized or applied in this part of the world, but then the continent is still making strides towards that. So on that note, that is where the Africa Arbitration Academy came in with a protocol on virtual hearings in Africa, that is for arbitration. So the academy innovatively came up with the first guideline that is called the Africa Arbitration Academy Protocol on virtual hearings in Africa. So the protocol has recommendations on how virtual hearings should be conducted. That is, the specific challenges or circumstances that may arise, they were all addressed. So and the core or the essence of your question, it's embedded within this particular protocol. So I'm just going to give a short and quick review about this protocol, and I hope it answers your question. So the objectives of this protocol is firstly it provides guidelines for arbitrations in Africa where physical hearing is not possible, probably because of health, safety, or costs. You understand? So the protocol gave guidelines for hearing of arbitral proceedings in Africa, especially where the cost of transportation for the different disputing parties is going to be high, or where the safety would be in check, or the health of the disputing parties are in question. Then the protocol provides guidelines for the arbitral proceedings to be held virtually. Now the next one is that it serves as guiding standards for when African governments are drafting their own rules or laws, because as it stands now, most of African countries do not have an existing law on virtual court proceedings. So Africa Arbitration Academy innovatively came up with this idea to bring out a guiding standard for when African governments will draft their rules and laws, that is in this post-COVID era that we are. So the next one is to ensure smooth running of virtual hearings with minimal technical issues. So the protocol also gave guidelines that will ensure that virtual hearings are being held with little or no technical issues. We know in Nigeria also, like I said, technology has not really is not our strong side, and then the network issues is very prevalent. So this particular protocol, the guidelines that are laid down in the protocol ensures that some particular measures are being set in place, some particular boxes are being ticked before virtual hearings is likely to hold. So in the sense that I'm just going to list that, firstly, the protocol gave a kind of instruction to ADR houses, like my president has mentioned, ADR houses like the Lagos Multi-Door Courthouse and other courthouses, multi-door courthouses that serve as alternative dispute resolution houses, that they should provide and permit disputing parties to use their technical secure rooms for hearing of arbitral proceedings. So then this is going to get rid of any other personal technical issues one may have, maybe use of a faulty device, or connecting with an unsecure Wi-Fi connection and other technical issues. So that's that. Then the final one I'm going to mention is that it promotes the use of reliable technology in arbitral proceedings. So the protocol, in line with the previous objective I mentioned, it promotes the use of reliable technology in the sense that it gave some particular standards, some particular rules on the kind of technology to be utilized during this proceeding, so as to avoid the use of any kind of wrong devices during the arbitral proceeding that may lead to further issues. So then I'm just going to round up by saying that the protocol has annexes, has 5 annexes after the protocol. At the ending part of the protocol, you can download the ebook and then you would see these 5 annexes I'm talking about. So the first annex is mostly about minimum cyber security standards, like I said, then using non-secure Wi-Fi connection, and that the parties should be able to, and the arbitral tribunal all should be able to test run the platform and test run the virtual court hearing and every other protocol that is going to be used for the virtual court hearing, using of password protected devices, and even the use of artificial intelligence for user authentication or facial recognition. Then the Annex 2 gave a guideline on a draft for the model Africa Arbitration Academy arbitration clause. So just like we have ADR clauses in our contract or terms of contract, Annex 2 provides a draft that allows parties to include a clause for virtual court hearing whenever a dispute arises. Then Annex 3 talks about the virtual hearing agreement. So before the virtual court hearing or the virtual arbitral hearing would commence, the parties have to submit a virtual hearing agreement, which is from the clause in Annex 2, a signed agreement that they agreed to using a virtual court hearing for the arbitration. And then Annex 4 is a background, that is the background history of the dispute. So what led to the decision of the disputants to opt for virtual hearing rather than a physical arbitral proceeding. Then they would submit also a list of participants that would appear during the virtual arbitral proceedings, and where would it hold? Is hearing locations? Is it going to be on Zoom? Is it going to be on Google Meet? Is it going to be Google Hangouts, or would it be on Skype, or even the Microsoft Teams as we are using currently? And then finally, the date and the time for the date and time for the hearing. Then finally, the Annex 5 talks about a guideline draft for the witness oath. So as many witnesses as possible that are going to be called, then there's a guideline draft for the witness oath. Thank you very much, and I am very grateful for the opportunity to share my thoughts on alternative dispute resolution in Nigeria. Thank you.
Thank you, Courage, for this very insightful presentation on basically all the characteristics of the African Arbitration Academy Protocol on virtual hearings. It is really interesting and nice to hear that such a legislation has been passed, and it establishes minimum standards for the virtual hearings and makes it so easy to actually continue with the proceedings online for the parties. I would like to thank you all for participating. For our listeners, that was our podcast for today. And I want to give a special thanks for Courage and also his colleagues who have shared their insightful experience and knowledge with us. And thank you all for accepting our invitation for our first episode on exploring ADR in Nigeria. It was a real pleasure having you.
Thank you. It's good to be here.
Thank you very much.
Thank you very much.
You've reached the end of this episode. If you have enjoyed it, follow us on Spotify, subscribe to our YouTube channel, and check out our weekly blog posts on our website. Thank you for listening.